The Philippine Constitution, Article 7, Executive Department. Section 1. The executive power shall be vested in the President of the Philippines. Section 2. No person may be elected President unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Section 3. There shall be a Vice President who shall have the same qualification and term of office and be elected with and in the same manner as the President. He may be removed from office in the same manner as the President. The Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. Section 4. The President and the Vice President shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 13th day of June next following the day of the election, and shall end at noon on the same date 6 years thereafter. The President shall not be eligible for any re-election. No person who has succeeded as President and has served as such for more than 4 years shall be qualified for election to the same office at any time. No Vice President shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Unless otherwise provided by law, the regular election for President and Vice President shall be held on the second Monday of May. The returns of every election for President and Vice President duly certified by the Board of the Canvassers of each province or city shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall, not later than 30 days after the day of the election, open all the certificates in the presence of the Senate and the House of the Representatives in joint public session. In the Congress, upon determination of the authenticity and due execution thereof, in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected. But in case 2 or more shall have an equal or highest number of votes, one of them shall forthwith be chosen by the vote of majority of the members of both houses of the Congress, voting separately. The Congress shall promulgate its rules for the canvassing of the certificates. The Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election, returns, and qualifications of the President and the Vice President, and may promulgate its rules for the purpose. Section 5. Before they enter on the execution of their office, the President, the Vice President, or the acting President shall take the following oath or confirmation. I do solemnly swear that I will faithfully and conscientiously fulfill my duties as President of the Philippines, preserve and defend its Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. Section 6. The President shall have the official residence The salaries of the President and the Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent, during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. Section 7. The President-elect and the Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a President shall not have been chosen, the Vice President-elect shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or shall have become permanently disabled, the President-elect shall become the Vice President-elect shall become the President. Where no President and Vice President shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or Vice President shall have been chosen and qualified. The Congress shall, by law, provide for the manner in which one who is to act as President shall be selected until a President or Vice President shall have qualified. In case of death, permanent disability, or inability of the officials mentioned in the new preceding paragraph. Section 8. In case of death, permanent disabilities, removal from office, or resignation of the President and the Vice President shall become, or resignation of the President, the Vice President shall become the President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both President and Vice President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected and qualified. The Congress shall, by law, provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He will serve until the President or Vice President shall have been elected and qualified, and be subject to the same restriction of powers and disqualification as the acting President. Section 9. Whenever there is a vacancy in the office of the Vice President during the term for which he was elected, the President shall nominate a Vice President from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. Section 10. The Congress shall, at 10 o'clock in the morning of the third day after the vacancy in the office of the President and the Vice President occurs, convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a President and a Vice President, to be held not earlier than 45 days, nor later than 60 days from the time of such call. The bill calling such special election shall be deemed certified under Paragraph 2, Section 26, Article 6 of this Constitution, and shall become law upon its approval on third reading by the Congress. Appropriations for the special election shall be charged against any current appropriations and shall be exempt from the requirements of Paragraph 4, Section 25. Article 6 of this Constitution. The convening of the Congress cannot be suspended, nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Section 11. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmit to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Whenever a majority of all the members of the Cabinet transmit to the President of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the House and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should a majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For the purpose, the Congress shall convene, if it's not in session, within 48 hours in accordance with its rules and without need of call. If the Congress, within 10 days after receipt of the last written declaration, or if not in session, within 12 days after it is required to assemble, determines by a 2/3 vote of houses voting separately that the President is unable to discharge the powers and duties of his office, the President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Section 12. In case of serious illness of the President and the public shall be informed of the state of his health, the members of the Cabinet in charge of national security and foreign relations, and the Chief of Staff of the Armed Forces of the Philippines shall not be denied access to the President during such illness. Section 13. The President, the Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. They shall not, during said tenure, directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. The spouse and relatives by consanguinity or affinity within the fourth civil degree of the President shall not during his tenure be appointed as members of the constitutional commissions or the office of the Ombudsman, or as secretaries, undersecretaries, chairmen, or heads of bureaus or offices, including government-owned or controlled corporations and their subsidiaries. Section 14. Appointments extended by an acting president shall remain effective unless revoked by the elected president within 90 days from his assumption or reassumption of office. Section 15. 2 months immediately before the next presidential election and up to the end of his term, a president or acting president shall not make appointments except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Okay, 2 months. Section 16. The President shall nominate, and with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, other public ministers, and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in courts, or in the heads of department, agencies, commission, or boards. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproved by the Commission on Appointments or until the next adjournment of the Congress. Section 17. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Section 18. The President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus, or place the Philippines or any part thereof under martial law within 48 hours from the proclamation of martial law or the suspension of the privilege of writ of habeas corpus. The President shall submit a report in person or in writing to the Congress. The Congress voting jointly by a vote of at least majority of all its members in regular or special session may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress, if the invasion or rebellion shall persist and public safety requires it. The Congress, if not in session, shall within 24 hours following such proclamation or suspension convene in accordance with its rules without need of a call. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies, or and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. Section 19. Except in cases of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, communications, and pardons, and remit fines or forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all members of the Congress. Section 20. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Majority Board and subject to such limitations as may be provided by law. The Monetary Board shall, within 30 days from the end of every quarter of the calendar year, submit to the Congress a complete report of its decision on applications for loans to be contracted or guaranteed by the government or government-owned or controlled corporation, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law. Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all members of the Senate. Section 22. The President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. Section 23. The President shall address the Congress at the opening of its regular session. He may also appear before it at any other time. Article 8. Judicial Department. Section 1. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of the justice. Judicial power includes the duty of the courts of justice. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Section 2. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. No law shall be passed reorganizing the judiciary when it determines the security of tenure of its members. Section 3. The judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year and, after approval, shall be automatically and regularly released. Section 4. 1. The Supreme Court shall be composed of a Chief Justice and 14 associate justices. It may sit en banc or in its discretion in division of 3, 5, and 7 members, Any vacancy shall be filled within 90 days from the occurrence thereof. 2. All cases involving the constitutionality of a treaty, international or executive agreement, or law which shall be heard by the Supreme Court en banc, and all other cases which under the rules of court are required to be heard en banc, including those involving the constitutionality, application, or operation of the presidential constitutionality, presidential decrees, proclamations, orders, instructions, ordinances, and other regulations shall be decided within the occurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted their own. 3. Cases or matters heard by the division shall be decided or resolved within the concurrence of a majority of the members who actually took part in the deliberations of the issues in the case and voted thereon, and in no case without the occurrence of at least 3 of such members. When the required number is not obtained, the case shall be decided en banc, provided that no doctrine or principle of law laid down by the court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. Section 5. The Supreme Court shall have the following powers. 1. Exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. 2. Review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the rules of court may provide final judgment or orders of lower courts in a. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. B. All cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. C. All cases in which the jurisdiction of any lower courts is in issue. 4. D. All criminal cases in which the penalty imposed is reclusion perpetua or higher. E. All cases in which only an error or question of law is involved. 3. Assign temporarily judges of lower courts to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. 4. Order a change of venue or place of trial to avoid miscarriage of justice. 5. Promulgate rules concerning the protection and enforcement of constitutional rights, pleadings, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and the legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. 6. Appoint all officials and employees of the judiciary in accordance with the Civil Service Law. Section 6. The Supreme Court shall have administrative supervision over all courts and any personnel thereof. Section 7. 1. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is a natural-born citizen of the Philippines. A member of the Supreme Court must be at least 40 years of age, at and must have been 14 years or more a judge of the lower court or engaged in practice of law in the Philippines. 2. The Congress shall prescribe the qualifications of judges of lower courts, but no person may be appointed judge thereof unless he is a citizen of the Philippines and a member of the Philippine Bar. 3. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Section 8. 1. A judicial and bar council is hereby created under the supervision of the Supreme Court, composed of the Chief of Justice and as ex officio chairman, the Secretary of Justice, and a representative of the Congress as ex officio members, and a representative of the Integrated Bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. 2. The regular members of the council shall be appointed by the President for a term of 4 years with the consent of the Commission on Appointments of members of the members first appointed. The representative of the Integrated Bar shall serve for 4 years, the professor of law for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. Section number 3. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceeding. 4. The regular members of the council shall receive such emoluments as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. 5. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Section 9. The members of the Supreme Court and the judges of lower courts shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. Section 10. The salary of the Chief of Justice and of the Associate Justices of the Supreme Court and of judges of lower courts shall be fixed by law. During their continuance in office, their salaries shall not be decreased. Section 11. The members of the Supreme Court or judges of the lower courts shall hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court and Bank shall have the power to discipline judges of lower courts or order their dismissal by a vote of a majority of the members who actually took part in the deliberation on the issues in the case and voted thereon. Section 12. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative function. Section 13. The conclusions of the Supreme Court in any case submitted to it for decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect signed by the Chief Justice shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any member who took no part or dissented or abstained from a decision or resolution must state the reason thereof. The same requirements shall be observed by all lower collegiate courts. Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. no petition for review or motion for reconsideration of a decision of the court shall be refused, due course, or denied without stating the legal basis thereof. Section 15. 1. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from the date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all lower courts. 2. A case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. 3. Upon the expiration of the corresponding period, a certification to this effect signed by the Chief Justice or the presiding judge shall forthwith be issued, a copy thereof attached to the record of the case or matter and served upon the parties. The certification shall state why decision or resolution has not been rendered or issued within said period. 4. Despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted thereto for determination without further delay. Section 16. The Supreme Court shall, within 30 days from the opening of each regular session of the Congress, submit to the President and the Congress an annual report on the operations and activities of the judiciary.